Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to deal with a case law of Karnataka High Court. The Karnataka High Court Single Justice M. Nagaprasanna is M. Nagaprasanna. He refused to quash a cheating case registered against an advocate under 420 IPC. What is this case? Why the refusal was observed by the court? All these things we are going to discuss in the later part of this video. You can read the case as Sri Palaksha SS. Sri, his advocate Sri Palaksha SS versus is definitely state of Karnataka. So Palaksha is correct. Son of Srivanna, aged about 39 years, advocate by profession. He is from Shimoga. His place of practice was Coorg. So that petition was filed, or the petition under 482 was filed against the state, represented by Vidhan Soudha PS, represented by Special PP High Court of Karnataka and others. It is there. So why all these things have come? So better know the genesis of the case. By now you might have known that the so-called Palaksha is a practicing advocate in Coorg. He is from Shimoga, but he is practicing it. He has got 13 years of service, 13 years of practice as an advocate, because he got enrolled in the Bar Association on 15/9/2006. Right? Now, he has got 13 years of service. He is practicing in High Court of Karnataka also. During the year 2019, there was the so-called advertisement for the post of directly recruited judges, district judges. So the advertisement given on 21/10/2019, he applied for the same, and he was successful through the mains, and even through the mains he completed on 15/2/2020, and he appeared for the YOC on 14/8/2020. Ultimately, he is in the selected list. Now the real trouble came. So then verification will start. In the verification process, the advocate or whoever, the person, he has to give an affidavit, or he has to fill up the so-called testimonials. Here the important point: whether any cases are pending against you, whether any FIRs are registered against you, all these things will be asked. In that connection, in my previous videos also, I told you that even though the cases ended in acquittal, you have to mention the same. The purpose of asking about the previous cases, involvement in previous cases, is to verify whether you will be fit to act as a judge or fit to act for the post or not. For that purpose, to take a decision, you have to give all the information. No doubt, this man has said no. He said no pending cases. He is also correct, because cases are not pending against him. Of course, only one case, that too under 125 CRPC, the case filed against him by his wife. I think he has got second marriage also. Right, that is only pending, 125 CRPC. That's not a serious case. As regards other case, in 4 cases he was the complainant, in 6 cases he was the accused, and all the cases either they were acquitted or they were settled in Lok Adalat. All the things have been settled. It's a good thing. But the problem is, now when the verification process has gone, he was given a memo stating that so many cases are pending against him, but he has not given the information. Then he has given reply, ultimately appeared before them. He said by oversight or human error, he did not write it. And at the beginning, he said that it is not necessary, because the column says how many cases are pending against you. No cases are pending. Therefore, he did not give it. Then the court did not agree. Ultimately, the court has directed Vidhan Soudha Police Station to register a case of cheating against him for suppressing the facts. So therefore, Honorable Justice M. Nagaprasanna, he clearly stated that fraud and misbehavior, they cannot dwell together. Fraud can never tell. So fraud is nothing but cheating. Of course, in the advocate on behalf of the so-called our great man, what is his name? Palaksha. He stated that in case of cheating, there should be some delivery of property, all these things. But please remember, he is a lawyer. He knows what is right and what is wrong, what is a crime. He has been complained in so many cases. He has been accused in so many cases. Is it not his duty to inform the court? This is the question put by the Honorable High Court of Karnataka. Charge sheet is filed, no doubt, as the complainant, he attended so many courts. So, whether he knows the case, human error, it cannot be accepted. No doubt, they may not be intentionally done this mistake. As the software request say yes or no, he has said no, but he has to give the explanation. Right? So ultimately, Honorable Justice, he said the fraud and misrepresentation, they cannot dwell together. Therefore, the case cannot be quashed under 482 CRPC. Now he has to face the trial. So please remember, this is the effect of not filling the testimonials properly, not giving the information properly. Otherwise, had he clearly mentioned that so many cases were registered against him and so many were disposed, yes, definitely, he would have been appointed. That's my presumption. Whether he would have been appointed or not, it's a different thing. So at least he should have been clear. When he is not clear, such problems will come. So please take a note of it and read the case law and enrich your legal knowledge. With this, I am concluding. Thank you very much.